Hello and welcome to the channel. Today, we're diving deep into something that affects nearly everyone in the workforce: employment contracts and your rights, especially if you're an agency worker. It sounds complicated, but I promise we'll break it down into simple, easy to understand pieces. So, whether you're starting a new job, working through an agency, or just curious about your rights, you're in the right place. First things first, what exactly is an employment contract? Simply put, it's a legally binding agreement between you and your employer. It lays out the conditions of your employment, including your rights and responsibilities, and also the responsibilities of your employer. Once you accept a job offer, you have a contract. This agreement doesn't always have to be a single written document. It's actually made up of a few different things. You have the express terms, which are things that had been specifically agreed upon, either in writing or verbally. This includes your pay, your working hours, and your holiday entitlement. Then there are implied terms. These aren't written down, but are understood to be part of the contract. For example, there's an implied term of mutual trust and confidence, meaning neither you nor your employer will act in a way that could destroy the employment relationship. There are also terms incorporated from other documents, like a staff handbook, and terms that are required by law, known as statutory terms, such as the right to a minimum wage. Your employer must give you a written statement of the main terms and conditions of your employment on or before your first day of work. This is a legal requirement. This document should include key details, like the names of you and your employer, your start date, how much and how often you'll be paid, your working hours, holiday entitlement, and your job title or a brief description of your work. It's a crucial document, so make sure you receive it and read it carefully. Now, let us clear up a common point of confusion: the difference between an employment contract and a contract for services. If you have an employment contract, you're an employee. This gives you the most employment rights. If you have a contract for services, you're likely self-employed or worker. The term worker covers a broader category of people, including agency workers, and they have many, but not all, of the same rights as employees. For example, workers are entitled to the national minimum wage, paid holidays, and protection against discrimination, but they don't typically have rights like protection from unfair dismissal or statutory redundancy pay. The distinction is important, and it depends on the reality of your working relationship, not just what your contract says. Sometimes, your terms and conditions aren't just decided between you and your employer. They might be set through a collective agreement. This is when a trade union or a staff association negotiates with an employer or a group of employers on behalf of a group of workers. These agreements can cover things like pay, working hours, and training. If your workplace recognizes a trade union and there's a collective agreement in place, some of its terms might automatically become part of your individual employment contract. Okay, let's shift gears and focus on a huge part of the modern workforce: agency workers. If you find work through a temporary work agency, your situation is a bit different. You're not an employee of the agency, nor are you an employee of the company where you're placed, which is called the hirer. Instead, you have a contract with the agency itself. This is often called a contract for services or terms of engagement. When you sign up with an agency, they must provide you with a key information document. This is super important. It's a short, clear document that outlines your pay, including how any fees or deductions will be calculated, who is paying you, and an estimate of your take-home pay. It also clarifies your employment status and any benefits you're entitled to. This document is designed to give you transparency from the very beginning, so you know exactly what you're signing up for. Never start work for an agency without receiving and understanding this document. For those of you in the entertainment or modeling industries, there are specialized agencies with slightly different rules. These agencies might be allowed to charge you a fee for finding you work. However, there are strict regulations. They must give you written terms of business, and these terms must clearly state what fees they will charge and what services they will provide for that fee. Crucially, for most contracts with these specific agencies, you have a cooling-off period. This means you have a set amount of time after signing the contract during which you can change your mind and cancel it without any penalty. The length of this period should be clearly stated in your agreement. Now for one of the most vital protections for agency workers: the right to equal treatment. This is a game changer. From day one of your assignment, you have the right to access the hirer's shared facilities and services. This means you should be able to use the canteen, the child care facilities, or the company transport just like any permanent employee. You also have the right to be informed by the hirer about any job vacancies at their company, giving you the same opportunity to find a permanent position as other staff. But the rights don't stop there. After you've worked in the same role at the same company for 12 weeks, you trigger a whole new set of rights. This is known as the 12-week qualifying period. Once you complete this period, you are entitled to the same basic working and employment conditions as if you had been hired directly by the company. This is a big deal. It covers key terms like pay, working hours, rest breaks, and annual leave. Let's break that down. Pay includes your basic salary, as well as things like shift allowances, overtime rates, and bonuses that are directly linked to the quality or quantity of work you do. It means that after 12 weeks, you should be paid the same as a permanent employee doing the same job. This principle of equal treatment is fundamental to preventing agency workers from being used as a source of cheaper labor long-term. So, how do you count those 12 weeks? It's 12 continuous calendar weeks, starting from your first day on the assignment. A calendar week runs from Sunday to Saturday. It doesn't matter how many hours you work each week. Even if you only work 1 day a week, that week still counts towards your 12-week total. What happens if you have a break? Does the clock reset to 0? Not always. The 12-week count will pause if you take a break for certain reasons. For example, if you take a break of 6 calendar weeks or less for any reason, the count just pauses. When you return to the same role with the same hirer, the count picks up where you left off. The count also pauses for longer breaks related to sickness, jury service, or annual leave. For instance, if you're off sick for up to 28 weeks, the clock is paused, not reset. The same applies if you take any of your statutory leave, like maternity, paternity, or adoption leave. So, when does the clock actually reset back to 0? The qualifying period will reset if you start a new role with the same hirer that is substantively different. This can't be a minor change. The duties and skills required must be genuinely different. The clock also resets if you take a break of more than 6 calendar weeks between assignments with the same hirer, provided that break isn't for one of the protected reasons we just mentioned, like sickness or parental leave. Finally, if you move to a new assignment with a completely different hirer, the clock for your previous qualifying period ends, and a new one will start at the new company. Understanding these rules is your best tool for ensuring you're treated fairly. Knowing about the key information document, your Day 1 rights, and the 12-week qualifying period empowers you to ask the right questions and stand up for your entitlements. Don't be afraid to talk to your agency or a citizen's advice service if you think you're not getting the correct terms and conditions. To recap, your employment contract is the foundation of your working life. Agency workers have specific protections, including a key information document and, crucially, the right to equal treatment after a 12-week qualifying period. Knowing how this period is counted and when it pauses or resets is essential. I hope this has cleared things up for you. Navigating employment law can feel like a maze, but knowledge is power. If you found this video helpful, please give it a thumbs up and consider subscribing for more content that helps you understand your rights at work. Thanks for watching, and I'll see you in the next one.